I have received a letter from the Honourable Ruth Dyson seeking to debate under Standing Order 389 the Government's proposed new governance structure to replace the existing arrangements for the Canterbury earthquake recovery. This is a particular case of recent occurrence. The Government announced the proposed new structure at 12 noon today. It involves ministerial responsibility. The announcement about the new governance structure is an important one, likely to be of considerable public interest. However, the Government's announcement also indicated that legislation would be introduced to give effect to the new structure. Consideration of this bill will provide opportunities to debate the proposed new governance arrangements. For that reason, the application is declined. I call on Government Order of the Day number 1.
Government Notice of Motion number 1 regarding the appointment of the Judicial Conduct Commissioner and Deputy Commissioner.
Mr. Speaker.
The Honourable Chris Finlayson.
I move that pursuant to Section 7.2 and 8A2 of the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004, this House recommends His Excellency the Governor-General appoint Mr Alan Deans Ritchie as the Judicial Conduct Commissioner and appoint Catherine Mary Snook as the Deputy Judicial Conduct Commissioner, each for a term of 5 years, having noted that I advised this House in accordance with Sections 7.3 and 8A3 of the Act that the Chief Justice has been consulted about the proposed appointments. I wonder if members would like to make more noise on exiting the chamber.
Order, order. The Minister's making a reasonable point. Would members exiting the chamber do so with less interference to the Minister speaking? The Honourable Chris Finlayson.
Thank you, sir. The Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004 provides for the Office of Judicial Conduct Commissioner and sets out a statutory regime for dealing with complaints about the conduct of judges. If appropriate, the Commissioner or the Deputy Commissioner may recommend the appointment of a Judicial Conduct Panel to inquire into any matter about the conduct of a judge. The Act establishes processes that recognise and protect the requirement of judicial independence and natural justice. It is not a function of the Commissioner or the Deputy Commissioner to challenge or call into question the legality or correctness of any instruction, direction, order, judgment, or other decision given or made by a judge in relation to any legal proceedings. The positions, I should say, require persons who are of high standing in the community with demonstrated integrity. The proposed appointees must be familiar with the role of the judiciary, the principles of judicial independence, natural justice and procedural fairness, and be highly competent communicators. And in my experience, sir, I think I can say it's a very difficult job because while there are some people who may have a genuine complaint, there are also others who are vexatious and malevolent and complain, frankly, just to be unpleasant. And it is the role of the Commissioner and the Deputy to deal with all complaints expeditiously and justly, sometimes in very, very trying circumstances. I have consulted with the Chief Justice as required under the Act on both appointments. Mr Ritchie has been Deputy Judicial Conduct Commissioner since 2011. He was admitted as a barrister and solicitor in 1971. He practised with Spencer and Ritchie in Ashburton and Chapman Tripp Sheffield Young in Wellington for about 12 years. He was the Chief Executive Officer and Executive Director of Chapman Tripp from 1985 to 2008 and was a consultant to the New Zealand Law Society from 2008 to 2013. In fact, sir, I should have said he was the CEO of the Law Society from 1985 to 2008. He's a member and panel convener of the Parole Board. Ms Snook is a Wellington lawyer. She was admitted to the bar in 1991. She was employed by Minter Ellison Rudd Watts as a senior associate from 1997 to 2000, providing commercial legal advice to a broad range of private and public sector clients. From 2004 to 2008, she was employed in the Office of Treaty Settlements before returning to Minter Ellison Rudd-Watts in 2008, where she remained until 2010. In 2011, she too was appointed a member of the Parole Board, and in 2013 appointed a panel convener. The terms of appointment must be for not less than 2 years and not more than 5, and it is proposed that both Mr Ritchie and Ms Snook be appointed for terms of 5 years. The Commissioner and Deputy Commissioner are remunerated at a rate set by the Remuneration Authority. Can I take this opportunity to say something about the retiring Commissioner, Sir David Gascoigne? He was appointed in 2009 and did not seek reappointment. I want to place on record the government's appreciation and gratitude for the professional and conscientious manner in which Sir David has carried out his duties over the past 6 years. In the course of his career, sir, he has given a great deal to New Zealand. He was one of those who founded the Film Commission. He served on the boards of Te Papa, the Queen Elizabeth II Arts Council, and many, many other cultural organisations. He's a fine New Zealander who has served his country very well.
The question is that the motion be agreed to. The Honourable David Parker.